Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, Rosanna Mannan brings us a finder agreement from the world of finance. So, let's tear it down. Hey everybody, welcome back to the Contract Teardown Show from Law Insider. I'm Mike Whalen. I'm here today with Rosanna Mannan. Rosanna, how are you today?
I'm doing well, thank you.
I appreciate you joining me because you're about to tell me something that I know nothing about, which is always my favorite kind of episode because I get to learn new things while having a job. It's great. So we're going to go to this document. I'm sharing this with the folks at home. This is called a finder agreement, and there's all kinds of money words in here that I don't know what they are, and you're going to help me figure it out. Rosanna, before we dig into it, what is a finder agreement? When are we going to see this kind of thing?
So when you're in the Silicon Valley, you're around, a lot of investment, a lot of investors, and sometimes you can act as a finder where you introduce an investor to a startup founder. So you can get in California and in Texas, you can actually get money compensation based on just introducing your startup friends to investors. So let's dig into this finder's agreement. And otherwise, in other states, you would have to register as a broker dealer under the SEC to get money from the investment. But as a finder, we can dig in more to the finder's agreement to learn more.
Sure, and of course, these are not publicly traded companies, but they're big financial transactions. The SEC is involved. I suppose some of them could be publicly traded on the investor side. But let's start with the statement of services. If I go down to, this is section 1, there's quite a bit here. So if I'm understanding correctly, the relationship is this agreement is as between this pharmaceuticals company, and they're going to engage a finder, a person who's going to go help the company obtain financing through a private placement of the company's common stock, it says. Okay, so yes. The finder is the broker type person who's going to go find the relationship, and the pharmaceutical company is saying, I'm going to hire you to go do that. All right, all that's it. Under the statement of services, it says what that person's going to do. So they're going to identify and introduce to the company, potential investors in equity financing, each of which shall be an accredited investor, in quotes, as defined under Regulation D of the Securities Act, and each of which shall be set forth in Exhibit A attached thereto. What are you seeing in here in terms of who this person is supposed to find? They got to find somebody. It can't be a mom and pop operation. It's got to be accredited investor. What does that phrase mean? What do you see in here?
So the accredited investor just means the investor has a certain amount of investment money, and there's certain other requirements to be an accredited investor. I don't know the exact amounts. But, then also the finder has to be an individual, not an entity. So if you're a finder and you have, an LLC as your company, and maybe you're consulting, you can't have that LLC be a party. You yourself have to be a party to the agreement as a finder. And yes, you have to introduce the startup company here, pharmaceutical company, to actual accredited investor as defined under the SEC.
Got it. And for going and doing this work, they're going to get paid. Under Section 2, it talks about how they'll be paid. They will receive compensation for the services. They'll pay the finder a cash fee, titled equity cash fee, equal to 1% of all funds invested by the investors into the fund. And they'll also allow the finder the ability to purchase a number of company shares under some rules. What are you seeing in this compensation section, and where might this not work?
Right. This compensation section is really problematic because only brokers, dealers registered under the SEC can actually get compensation based on the investment and a bite into the actual securities of the investment. As a finder registered in California or Texas, you have to get a fee that isn't tied to the actual investment. So your startup company has to actually pay you out of their pocket and not as money coming in from the investment.
Got it. So they could say, as a flat fee for this, I'm going to give you $10,000 or whatever, but
Uh-huh.
saying it's 1% of the amount raised is okay.
Or you could
That's what's
say
great.
for every $200 million, for every $20 million investment, I'm going to give you $2,000. For every $100 million investment, I'll give you $2 million. You can structure it as an amount like per investment amount as well.
Got it. All right. Well, let's jump to 3, the representations, warranties, and covenants. So there's a bunch here, about each. The finder is not going to go out alone or through agents, hold any funds or securities. There's a bunch of rules for both the finder to not go out and misuse the company name and money and those kinds of things. And presumably, I'm not seeing any representations from the hiring company, unless I'm missing something. What are you seeing in the reps and warranties that apply to this particular situation?
Yeah, so the finder can't really be involved in the terms of the actual transaction. They can't be acting as a broker or dealer. They can't really participate in, like, they can't really help. They can't, I mean, as in terms of like try to persuade the investor to buy the securities of this company. They can't really, their job is just the introduction and maybe, a little bit of, you know, talk about, what's going on in their lives or, so, but nothing about the actual securities of the company or the transaction itself. So you're just kind of the intermediary kind of introduction finder introducing, but and you make these certain warranties that you're not going to be involved in the actual transaction itself.
Hmm. It's an interesting role because, like, you do want to lure people with some terms, but you're really just creating a relationship. That's interesting. Well,
Yes.
let's jump down to section 4, to the indemnification. And there are 2 sections here, A and B, and they both basically start with the same sentence. Obviously, they made this mutual. The finder agrees to indemnify and hold harmless the company, et cetera, against any and all losses, et cetera, et cetera. The same with the company. They agree to indemnify and hold harmless the finder, all its people, against any and all losses, claims, etc. These are 2 long sections, and I'm going to leave that with people to read it in the show notes. But what are you seeing in this indemnification that seems to be pretty mutual?
Yeah, I mean, I don't mind a mutual indemnification, but it should be, regarding third party claims, not any and all claims. So I would, if I was negotiating this contract, I would make it third party claims and, and against, misrepresentation of the finder or the company or the investor. So if there's a third party claiming misrepresentation, then you want to be indemnified by the other party, definitely. There's no other, I mean, you could also indemnify against willful, reckless misconduct, but these are really professional level people, and you don't really get too much negligence or reckless misconduct, but you definitely want to indemnify against misrepresentation.
Got it. All right. So section 6 now. We're under term and termination. Basically, unless and until terminated as set forth herein, the agreement will continue in full force and effect for an initial term expiring in 2006. I don't know what the active date of this thing is. Do you know? Like, how long is that term? Sorry, I'm looking for a start date, and don't see one. Oh, it says January blank date 2006. So it looks like it's going for like a month. Then it says that there's renewal at the expiration of this. The company may renew this agreement month to month with at least 10 days notification. And then there's requirements about how they can terminate with notice to each other if there's a breach or if they have, misrepresented the company in some way. And then there's some surviving provisions in there. What are you seeing in the term and termination? Do you think it's well adapted to this context?
Well, I would argue, you'd want a termination for convenience on both sides. Just either party can just, walk away if they want to, or have a term for at least, a year and then terminate for convenience. But yeah, I mean, you can craft it and it depends on the parties. I mean, how they have it here is fine. I mean, you can only terminate for breach and there's maybe a 2 month term, but it's how you want to craft the relationship. Like if you're a finder and you know this investor and you've known this company for a few years and you want to have a long-term relationship and you want to always bring on, you really believe in this company and you're always going to bring on investors for this company, then yeah, you want like a longer term. Maybe you just met, maybe you just met the startup and you think you want to bring on some investors, but you don't want to stay there long term. It just depends on how you want to craft the relationship, honestly.
I'm thinking about that in the big picture. My experience with VC companies, I've worked for a couple, and, I'm wondering what the commercial context is here. You identified this group as some pretty professional folks. I assume that there are standards. There's probably some kind of trade organization that they create standards for this, and then people comply with it or don't. But it seems to me like a permanent relationship if the hiring company is not the funder, which obviously the funder is going to try to find 100 different deals, 1,000 different deals, multiple ways to go. They're not working for the funder, it sounds like. They're working for the company that's seeking the funding. In my experience, the company seeking funding, a lot of times it will just try to go back to that same VC company and just get more and get more and get more. Explain the commercial context to us and where is the long-term relationship and how does that affect, whether there is one or isn't one, how does that affect how these people tend to behave? Do they tend to try to preserve these relationships and stay professional? Or is this kind of a turn and burn, we're doing quick flipping houses kind of deal? What's the experience like?
I mean, I think also that depends on the market. So right now, I think the market is more turn and burn, just trying to get the quick cash, just money in your pocket right away. But for if it's a better economy, then that can lead to longer standing relationships. You want to stay there, you want to hold on to that company like you hold on to stock. Um, so it just depends on the economy, honestly, I think.
I wanted to ask you, related to this, we're going to include over in the show notes, you sent me a link to some California code. It sounds like from the way you described that there's SEC requirements, sure, but there's also state-specific requirements.
Hmm.
Is the feeling that this document was not written for the California context and it should be? Do you feel like that California set of rules should be the standard rules that we should, apply in different jurisdictions? What's the
Hmm.
relationship between this document and California's regulations specifically?
So California actually asks for an additional document, asks for a disclosure agreement. So this document is signed by the company and the finder. The disclosure agreement discloses certain statements to the investor as well as the company. So all three parties are parties to that disclosure agreement. Um, but they're actually under the SEC. There's no finder's exemption under the SEC. You have to register as a broker dealer. Only two states allow the finder's exemption, which is California and Texas. So really, if you're not in California or Texas, you really can't work as a finder without being cited by the SEC and fined. So.
Hmm. Huh. Interesting. All right. Well, what a weird context, right? This is a particular gig in a particular economy in particular states, trying
Yes.
to make these very, the American economy, at least as much as we talk about it,
Yeah.
seems to be driven by these VC companies. They're probably a
And
relatively small part of the overall economy, but it's just an interesting context. Yeah.
And another thing for California, it needs to be a California transaction. So the bank accounts need to be in
Mm.
California, an investor needs to be, the finder needs to, be in California, but the California transaction, it has to be based in whatever that means legally. It could mean the bank accounts, it could mean the physical presence, but that's another hurdle to get
Mm.
into. Because if you're a finder and your companies, maybe your startups are in Germany and they're trying to get investment from people in Florida, that might not work. Even though you're based in California, you're under the finder's exemption in California. But because everybody else is everywhere else, and it doesn't count as a California transaction, then you wouldn't be able to get money from that introduction.
Mm.
That's
The
another thing to think about.
exceptionalism of Yeah, the exceptionalism of California and Texas in action. Well, I appreciate you bringing this to us, Rosanna. It's an interesting context for people who want to connect with you and learn more about these kinds of documents, these kind of deals, and the work that you do. What's the best way to connect with you online?
Yeah, just find me on LinkedIn, and just add me and send me a message, shoot me a message. I can, help with any mentoring if you're a law student or a new lawyer, or if you just have questions about contracts, my experience and my recommendations. It's I would recommend getting a subscription to Law Insider, definitely, because they have the biggest contracts database out there, and it's helped me a lot in my practice. So.
Well, that's great. I appreciate that. And we'll be sure to share your information over at lawinsider.com/resources. And if you want to be a guest on the Contract Teardown Show, just email me. I'm at community@lawinsider.com. We would love to have you and hear your insights. For today, Rosanna, thank you again for joining us, and we will see you all next time.
Bye.
Thanks so much for tuning in to this episode of the Contract Teardown Show from Law Insider. If you're enjoying the show, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show. We really appreciate it. Thanks again for listening, and we'll catch you in the next episode.